You say I make you nervous, a tragedy, I'm a beautiful disaster, a reckoning, you wonder how I got this way. You think I'm someone to be saved, someone to clean up and tame. Oh, some things never change, never change. You think I would look pretty on your arm once you cover up my bruises and battle scars, but it always ends the same. Can't bear the things I've had to face, got you crying on your knees in pain. Oh, some things never change, never change. Oh, you'll break your back to make me feel again, suffocate to make me breathe again, lose your mind from endless pain. Some things never change, never change. Oh, redemption never came. I stopped asking for.
All right, everybody. Justice is a Process is back here. We are going to attempt to cover the Daniel Howard case. Now, some big things happened over the weekend. He attempted to flee, it appears. Now, he is on day 10 of his trial, but he attempted to flee and is now had his bond revoked. He's sitting in jail, and they're going to be dealing with that in court this morning. But we are going to deal with getting caught up on the case. So without further ado, I'm going to be watching from mobile. We're going to be trying to get caught up on this thing as quick as we can. So we're going to watch it a little quicker than normal as much as we can. The acoustics in the courtroom aren't strong, so I don't want to go too fast because it wasn't very it may be hard to hear given to the acoustical issues in the courtroom. But this is a situation where Daniel Howard is accused of I guess he found his wife. She was shot in the head. He says it was suicide. The state says it was unaliving. So we'll find out what happens here, obviously. Clearly, the case must not be going well for him if he was trying to get out of town. So we'll have to, like I said, catch up and see what the deal is. So let's jump into the courtroom, and I'll see you guys in a little while.
Thank you. Please be seated. Members of the jury, just so you know, please don't be going in and out a lot. When you come in, we're all standing for you. So you're welcome to sit as long as you don't have to keep standing. Whenever you want to see it all across the court. All right, members of the jury, I'm going to now read you the preliminary jury instructions. As I indicated to you, I'll be reading these not to be impersonal in any way, but to remain accurate. You will receive copies of what I provided you at this time. Instruction number 1. During the course of this trial, you are instructed that you are not to discuss this case among yourselves or with anyone else, including any use of email, text messaging, tweeting, blogging, electronic bulletin boards, or any other form of communication, electronic or otherwise. Do not conduct any personal investigation or look up any information from any source, including the internet. Do not form an opinion as to the merits of the case until after the case has been submitted to you for your determination. And for such time as you are on this jury, I'm also instructing you not to watch or listen to local news while you're serving on this jury. Instruction number 2. Now that you have been sworn as jurors to try this case, I want to go over with you what will be happening. I will describe how the trial will be conducted and what we will be doing. At the end of the trial, I will give you more detailed guidance on how you are to reach your decision. Because the state has the burden of proof, it goes first. After the state's opening statement, the defense may make an opening statement or may wait until the state has presented its case. The state will offer evidence that it says will support the charges against the defendant. The defense may then present evidence, but is not required to do so. If the defense does present evidence, the state may then present rebuttal evidence. This is evidence offered to answer the defense's evidence. After you have heard all the evidence, I will give you additional instructions on the law. After you have heard the instructions, the state and the defense will each be given time for closing arguments. In their closing arguments, they will summarize the evidence to help you understand how it relates to the law. Just as the opening statements are not evidence, neither are the closing arguments. After the closing arguments, you will leave the courtroom together to make your decision. During your deliberations, you will have with you my instructions, the exhibits admitted into evidence, and any notes taken by you in court. Instruction number 3. This criminal case has been brought by the state of Idaho. I will sometimes refer to the state as the prosecution. As I mentioned to you earlier, the state is represented at this trial by prosecuting attorneys Stanley Mortensen, Julia Schopstall, and Arthur Bernard. Jason Johnson represents the defendant, Daniel Howard. Instruction number 4. Under our law and system of justice, the defendant is presumed to be innocent. The presumption of innocence means 2 things. First, the state has the burden of proving the defendant guilty. The state has that burden throughout the trial. The defendant is never required to prove his or her innocence, nor does the defendant ever have to produce any evidence at all. Second, the state must prove the alleged crimes beyond a reasonable doubt. A reasonable doubt is not a mere possible or imaginary doubt. It is a doubt based on reason and common sense. It may arise from a careful and impartial consideration of all the evidence or from lack of evidence. If, after considering all the evidence, you have a reasonable doubt about the defendant's guilt, you must find the defendant not guilty. Instruction number 5. Your duties are to determine the facts, to apply the law set forth in my instructions to those facts, and in this way to decide the case. In so doing, you must follow my instructions regardless of your own opinion of what the law is, or should be, or what either side may state the law to be. You must consider them as a whole, not picking out one and disregarding others. The order in which the instructions are given has no significance as to their relative importance. The law requires that your decision be made solely upon the evidence before you. Neither sympathy nor prejudice should influence you in your deliberations. Faithful performance by you of these duties is vital to the administration of justice. In determining the facts, you may consider only the evidence admitted in this trial. This evidence consists of the testimony of the witnesses, the exhibits offered and received, and any stipulated or admitted facts. The production of evidence in court is governed by rules of law. At times during the trial, an objection may be made to a question asked of a witness, or to a witness's answer, or to an exhibit. This simply means that I am being asked to decide a particular rule of law. Arguments on the admissibility of evidence are designed to aid the court and are not to be considered by you nor affect your deliberations. If I sustain an objection to a question or to an exhibit, the witness may not answer the question or the exhibit may not be considered. Do not attempt to guess what the answer might have been or what the exhibit might have shown. Similarly, if I tell you not to consider a particular statement or exhibit, you should put it out of your mind and not refer to it or rely on it in your later deliberations. During the trial, I may have to talk with the parties about the rules of law which should apply in this case. Sometimes we'll talk right here at the bench, and other times I will excuse you from the courtroom so that you can be comfortable while we work out any problems. You are not to speculate about any such discussions. They are necessary from time to time and help the trial run more smoothly. Some of you have probably heard the terms circumstantial evidence, direct evidence, and hearsay evidence. Do not be concerned with these terms. You are to consider all the evidence admitted in this trial. However, the law does not require you to believe all the evidence. As the sole judges of the facts, you must determine what evidence you believe and what weight you attach to it. There is no magical formula by which one may evaluate testimony. You bring with you to this courtroom all of the experience and background of your lives. In your everyday affairs, you determine for yourselves whom you believe, what you believe, and how much weight you attach to what you are told. The same considerations that you use in your everyday dealings in making these decisions are the considerations which you should apply in your deliberations. In deciding what you believe, do not make your decision simply because more witnesses may have testified one way than the other. Your role is to think about the testimony of each witness you heard and decide how much you believe of what that witness had to say. A witness who has special knowledge in a particular matter may give an opinion on that matter. In determining the weight to be given such opinion, you should consider the qualifications and credibility of the witness and the reasons given for the opinion. You are not bound by such opinion. Give it the weight, if any, to which you deem it entitled. Instruction number 6. If during the trial I may say or do anything which suggests to you that I am inclined to favor the claims or position of any party, you will not permit yourself to be influenced by any such suggestion. I will not express, nor intend to express, nor will I intend to intimate any opinion as to which witnesses are or are not worthy of belief, what facts are or are not established, or what inferences should be drawn from the evidence. If any expression of mine seems to indicate an opinion relating to any of these matters, I instruct you to disregard it. Instruction number 7. Do not concern yourself with the subject of penalty or punishment. That subject must not in any way affect your verdict. If you find the defendant guilty, it will be my duty to determine the appropriate penalty or punishment. As I indicated to you earlier, the death penalty is not a sentencing option for the court or the jury in this case. Instruction number 9. It is alleged that the crime charged was committed on a certain date. If you find the crime was committed, the proof need not show that it was committed on that precise date. Instruction number 10. If you wish, you may take notes to help you remember what witnesses said. If you do take notes, please keep them to yourself until you and your fellow jurors go to the jury room to decide the case. You should not let note-taking distract you so that you do not hear other answers by witnesses. When you leave at night, please leave your notes in the jury room, where they will be locked and not viewed. If you do not take notes, you should rely on your own memory of what was said and not be overly influenced by the notes of other jurors. In addition, you cannot assign to one person the duty of taking notes for all of you. At the end of the case, at the conclusion, our bailiffs will take your notes and shred them, so they won't be read back. I know you've heard this instruction many times, but let me sum it anyway. Instruction number 11. It is important that as jurors and officers of this court, you obey the following instructions at any time you leave the jury box, whether it be for recesses of the court during the day or when you leave the courtroom to go home at night. Do not discuss this case during the trial with anyone, including any of the attorneys, parties, witnesses, your friends, or members of your family. No discussion also means no emailing, text messaging, tweeting, blogging, posting to electronic bulletin boards, and any other form of communication, electronic or otherwise. Do not discuss this case with other jurors until you begin your deliberations at the end of the trial. Do not attempt to decide the case until you begin your deliberations. I will give you some form of this instruction every time we take a break. I do that not to insult you or because I don't think you are paying attention, but because experience has shown this is one of the hardest instructions for jurors to follow. I know of no other situation in our culture where we ask strangers to sit together, watching and listening to something, then go into a little room together and not talk about the one thing they have in common, what they just watched together. But there are at least 2 reasons for this rule. The first is to help you keep an open mind. When you talk about things, you start to make decisions about them, and it is extremely important that you not make any decisions about this case until you have heard all of the evidence and all the rules for making your decisions. And you won't have that until the very end of the trial. The second reason for this rule is that we want all of you working together on this decision when you deliberate. If you have conversations in groups of 2 or 3 during the trial, you won't remember to repeat all of your thoughts and observations to the rest of your fellow jurors when you deliberate at the end of the trial. Ignore any attempted improper communication. If any person tries to talk to you about this case, tell that person that you cannot discuss the case because you are a juror. If that person persists, simply walk away and report the incident to the bailiff. Do not make any independent personal investigations into any facts or locations connected with this case. Do not look up any information from any source, including the internet. Do not communicate any private or special knowledge about any of the facts of this case to your fellow jurors. Do not read or listen to any news reports about this case or about anyone involved in this case, whether those reports are in newspapers or the internet or on radio or television. In our daily lives, we may be used to looking for information online and to Google something as a matter of routine. Also, in a trial, it can be very tempting for jurors to do their own research to make sure they are making the correct decision. You must resist that temptation for our system of justice to work as it should. I specifically instruct you that you must decide the case only on the evidence received here in court. If you communicate with anyone about the case or do outside research during the trial, it could cause us to have to start the trial over with new jurors, and you could be held in contempt of court. While you are actually deliberating in the jury room, the bailiff will confiscate all cell phones and other means of electronic communication. Should you need to communicate with me or anyone else during the deliberations, please notify the bailiff. Instruction number 12. Each count charges a separate and distinct offense. You must decide each count separately on the evidence and the law that applies to it, uninfluenced by your decision as to any other count. The defendant may be found guilty or not guilty on some or all of the offenses charged. The clerk will now read the indictment and state the defendant's plea. Remember, the indictment is simply a description of the charge. It is not evidence.
In the District Court of the 1st Judicial District of the State of Idaho, in and for the County of Kootenai, State of Idaho plaintiff, Daniel Charles Howard, defendant. Count 1, that the defendant, Daniel Charles Howard, on or about the 10th day of July, 2020, in Kootenai County, Idaho, did, in committing a battery, inflict a traumatic injury or injuries upon the person of Kendy Howard, to wit, redness to her ear and bruising to her chest and arm, and where Kendy Howard and the defendant or household members. Count 2, that the defendant, Daniel Charles Howard, on or about the second day of February 2021 in Kootenai County, Idaho, did unlawfully, deliberately, with malice, aforethought, and with premeditation, killed Kendy Howard, a human being to wit, by asphyxiating her, all of which is contrary to the force and effect of the statute in such case made and provided and against the peace and dignity of the people of the state of Idaho. To these charges, he pled not guilty. Stanley T. Mortensen, Kootenai County Prosecutor, Parker Herron, Deputy Prosecutor.
Thank you. Before we begin, I believe the parties said earlier when I spoke with you all had agreed to exclude witnesses at such time, except at such time as they're testifying. Is that correct?
Yes, sir.
All right. We will turn now to opening statements. Cindy, go first.
Good afternoon, ladies and gentlemen. Normally I would move about, but I want to stay out of your way of the screen. Before I begin, I want to say that there are a lot of witnesses in this case, and my office is going to do its best to put them in chronological order. However, we've got about 50 or 60 witnesses, and some of them are coming from Seattle, some are coming from Pennsylvania, some are coming from Salt Lake, and they have some schedules we'd like to keep in mind. And so the order of the witnesses may be out of order, but we're going to ask you to look at the evidence in its totality. It's almost going to be somewhat like a Quentin Tarantino movie. Anyway, the last thing I want to say before I begin is that what I'm going to tell you is not evidence. I'm going to tell you how I believe the evidence is going to come in and what the evidence will show. So with that, I want to introduce you to Kendy Howard. Kendy was a mother of 2 adult children. Kendy was a grandmother. Kendy worked for Kootenai Health for nearly 20 years. Kendy loved bubble baths. She loved life and had future plans. This is Kendy Howard's family. She was the daughter of Wendell and Janie Wilkins. Kendy had a brother, Ryan. Kendy had a daughter, Brooke. When Brooke was 1 year old, she met and married Dan Howard. And together they had 1 son, Wyatt. Now, ladies and gentlemen, I'm going to introduce to you the state's motto. When you have eliminated the impossible, whatever remains, however improbable, must be the truth. Sir Arthur Doyle wrote this. He created a character we all know and love, Sherlock Holmes. Over 100 years ago, Sherlock Holmes, perhaps the most famous detective of all time, spoke these words. These are the words I want you to remember throughout this trial. You've heard this before. It's just called something else. We call it process of elimination, or just simple logic. Ladies and gentlemen, Dan Howard is an ex-Marine. I mentioned to you earlier he had a law enforcement career. He started that career in California, and it was in California where he first trained with what is called the carotid restraint technique. And you're going to hear about that technique. It is different than a chokehold. Chokehold is when you cut somebody's oxygen off. Carotid restraint is when you cut their blood flow off. And when you cut somebody's blood flow off, they pass out. But when you apply that technique too long, they die. Dan Howard moved to Idaho, became a deputy sheriff in Idaho County, and then in 1994 he became an Idaho State Trooper. And he stayed there for 20 years and he received a lot of training and experience, to include SWAT. He was a firearms instructor. He was a defensive tactics instructor. He had the training, knowledge, and experience to be able to process crime scenes and collect evidence. I'm talking about DNA, I'm talking about fingerprints, I'm talking about ballistics. Ladies and gentlemen, there are 2 sides to that coin. Having the ability to read a crime scene and collect evidence also gives you the ability to stage a crime scene and not leave evidence. After leaving law enforcement, Dan would go to Alaska for 3 weeks at a time, where he was an equipment operator in the Alaska North Slope. Then he'd come home for 3 weeks. Then he'd go to work for 3 weeks. Then he'd come home for 3 weeks. And that's how this story starts. Dan Howard's been charged with domestic battery. On July 10th, 2020, Kendy calls 911. She does not disclose much to the cops. The next day, however, she starts sending one of her best friends pictures. And these pictures are bruising on her body. In the days following, Kendy and Dan go camping with some friends. One of these friends is the friend that Kendy was sending these bruises to her in picture. When Kendy shows up, the friend sees the bruises in person. That's count 1, domestic battery. Following this, Kendy starts preparing to divorce Dan. Kendy, she gets a prescription for Prozac. She obtains it from a weight loss clinic. Kendy has fallen in love and begun a romantic relationship with somebody she met in high school. This is somebody who her parents know and are hanging out with. Kendy's beginning to move on for life. Kendy's in the process of buying a house in Kootenai. Closing date in April, months away. She buys a hot tub, other various items, and makes plans to renovate this new home she's buying. It's new to her. It's used. Kendy even tells her coworkers here at Kootenai Health that she's going to be getting a new job down in Kootenai. She schedules a mommy makeover appointment, tummy tuck, breast augmentation, plans for the future, plans for her new life away from Dan. She buys new prescription glasses at Costco. She's constantly sharing plans with her friends, family, and her boyfriend. Together, Dan and Kendy have over $2 million in assets. And in Idaho, we call that community property. They have a house on 10 acres in Athol. They have 2 parcels of land in Spirit Lake. They have toys, they have a tractor, vehicles, motorcycle, boat, camper. Retirements, each of them have their own retirements. A lot of cash. Hardly any debt. Again, community property means that in the divorce, Kendy is going to get half of everything, even Dan's law enforcement retirement. January 2021. On the 26th, Kendy meets with the divorce attorney. This is happening when Dan is in Alaska. Her family knows. Dan doesn't know yet. He's working in Alaska. She meets with the defense attorney who explains the divorce process and answers her questions. Kendy leaves the meeting with divorce paperwork in hand. 2 days later, she picks Dan up from the airport. He's returning home from Alaska. She tells Dan that she wants a divorce. She fills out the divorce paperwork with Dan. Next day, Kendy wakes up early in the morning. Dan is standing over her. Kendy sees that Dan is dressed in dark clothing and wearing gloves. Dan's holding an object. Kendy sees a handgun magazine laying on the floor. Kendy calls her boyfriend, who in turn calls her parents, and Kendy's mom calls 911. Kendy tells the officers that she thinks Dan was about to kill her. Kendy leaves the house that night, drives to Kootenai, and stays with her parents. A few days later, Kendy returns. On February 1st, Dan and Brian, who are friends, this is Kendy's brother, Brian, they work in Alaska together. Dan's father needs help moving something about 3 hours south of town. Dan picks Brian up, and they drive down south. It's a 3-hour trip, a lot to talk about. I think Brian maybe lives halfway between, so maybe an hour and a half between the two of them. Dan is suspicious that Kendy's having an affair, so Dan confronts Brian with this, and Brian confirms that Kendy is having an affair. Dan doesn't sleep that night. Brian can hear Dan pacing all night. The next day, they wake up. Dan drives recklessly the whole way back to town. Same day, February 2nd. Kendy's last day. Kendy goes to work. Kendy hears that her new home has passed inspection. Kendy gets her nails done. This is somebody who isn't suicidal. Kendy goes to McDonald's on her way home to Athol and gets dinner. Later that night, Dan calls 911. Tells law enforcement that Kendy shot herself. Deputies arrive. Detectives arrive. Red flags are going up. Some very experienced deputies and detectives are starting to become suspicious of what they see. They find Kendy naked in a bathtub. Even brand new, inexperienced deputies are starting to notice that things are not adding up. Crime scene. Dan says Kendy shot herself. Gunshot wound to the mouth is found. No witnesses. Dan's the only one in the house. Officers notice some things. Again, Kendy's naked in the bathtub. Water was still warm. There's bubbles in it. Dan appears to be crying. There's no tears. None of Kendy's clothes are found in the bathroom. There's glass on the bedroom floor. There's a lot less blood in the bathroom than the deputies would expect after somebody's been shot in the mouth. Dan has fresh deodorant on his shirt. There are clothes in the dryer. Wood-burning stove is cooking. When somebody dies, it's very common for the body to go to Spokane, where there's an autopsy. This autopsy was performed by a pathologist, a medical examiner. This medical examiner had a long career and had done hundreds of autopsies. He was about to retire. This is Dr. Howard, no relation to Dan. Dr. Howard has short-timer's disease. He's shown up to work, he's performing autopsies, but his colleagues are noticing he's kind of checked out. The autopsy fails to recognize some important things that the detectives are picking up on. Kendy has bruising on her body that got there before she died. Medical experts can determine that on various places of her body. There's a second-degree thermal burn on Kendy's arm. When people get into the bathtub with a burn, it hurts. There's a reason why people don't get into the water when they have a burn on their arm.
Say it again.
Argument. Argument.
I'll move on, Your Honor. Evidence will show that Kendy suffered a broken jaw before she died. Evidence will show that Kendy had signs of suffocation on her body, to include bruising on her chest. Evidence will show that there was a lack of blood at the crime scene. Ladies and gentlemen, there's a timeline here. February 2nd, the day of Kendy's death. February 3rd is the autopsy. Almost 5.5 months later, we get a coroner's report. After an autopsy, the autopsy then goes back to Kootenai County, and our Kootenai County coroner reviews the death, all the evidence. And when a coroner gets all this evidence, they have to fit the death into one of 5 categories. Was this death natural causes? Cancer. Was this death an accident? Were they hiking and they slipped off the cliff and they fell to their death? Was this a suicide? Was this a homicide? When the coroner can't pick one of those 4, they pick undetermined. And that is exactly what happened in this case. The sheriff's office considered that another red flag. After receiving the coroner's report, a 2-year investigation was conducted into Kendy's death. Ladies and gentlemen, the evidence will come in and will demonstrate that this was not a suicide. There will also be evidence that this was a homicide. Evidence will show that Kendy died of asphyxiation. That's the result of a carotid restraint, something Dan knew how to do. Evidence will show that Kendy was shot in her mouth, but that happened after she was already dead. This explains the lack of the blood at the crime scene. When somebody's dead, their heart slows down and then stops beating. When the heart is slowing down and stops beating, less blood is leaving the body. Loss or lack of blood at the crime scene. The evidence will show that this scene was staged to look like a suicide. 3 questions. Who? Who had the opportunity? Well, Dan was the only other one in the house. Evidence will show you that. How? Who had the ability to stage a crime scene? Dan had the law enforcement training and experience needed to hide or leave little evidence at the scene. Why? What's the motive? Kendy was going to take half of everything in the divorce. $1 million. Ladies and gentlemen, after hearing all this evidence, you are going to have information that the coroner did not have when ruling Kendy's death undetermined. After all the evidence comes in, you're going to be able to rule out natural causes. You're going to be able to rule out accident. If it's suicide or homicide, it's undetermined. But you're going to hear evidence that this was not a suicide. Ladies and gentlemen, if it's not suicide, it's no longer undetermined. Motto of the case: if you eliminate the impossible, all that's left is the truth. This evidence will show that Dan Howard is guilty of murder. Thank you.
Thank you, Ms. Mortensen. Mr. Johnson, your opening.
You'll hear that Kendy was living a double life for quite some time. And speaking about impossible, you will hear from the state's psychological expert that it is impossible to determine Kendy's suicidality, whether she was suicidal. Ladies and gentlemen, I'm Jason Johnson. Your Honor, members, ladies, gentlemen of the jury, counsel. I want to start with tonight, February 2nd. Dan calls 911 about 10:45. You'll hear that he stayed on the phone. His demeanor on that 911 call, weeping, particularly when the dispatcher or the 911 operator mistakes that he was calling about his son. About 2-3 minutes into the call, instead of his wife, she asked him, "How old is your son?" And he was confused. And that reaction there. And law enforcement shows up, and they initially, officer or deputy Wheeler, who's relatively new, makes some observations. Well, his cheeks are red, he's crying, but I don't see tears. And he takes some initial photos. At that point, it's a death investigation. Officers show up, detectives show up, 3 detectives, Detective Wheeler, Detective Wheeler, Detective Loud. And obviously, in this death case, death investigation, you're going to do some due diligence and rule out anything untoward. But Detective Mortrup then takes photos 7 hours later, 6 to 7 hours later, based upon the timestamps of the photos, where she's still in the tub, still with blood. The medical examiner refers to a blood line across her body, where she had been sitting in the tub, and the water had gone down, and you see that blood line. You'll see the amount of blood caked on her back when she was removed from the autopsy examination. They do their investigation. Initially, they conduct a search warrant at that time. And they leave about 9:45, officers and law enforcement leave about 9:45 on the 3rd, the morning of the 3rd. Later that morning, autopsy was performed by Dr. Howard. And Dr. Howard specifically found that the cause of death...
Objection, Your Honor. Sidebar?
Yes. Members of the jury, this is going to take a little longer conversation with the attorney, so I'm going to excuse you shortly while I continue discussing the lawyers. All rise, please. We were having a sidebar that wanted to pick up a court reporter, and so, what said you'd like to state your objection?
Thank you. Your Honor, I'm going to try to keep this very simple and short. This was litigated well before trial. Dr. Howard's conclusions are hearsay. They can't come in except through Dr. Howard. Now, there are going to be some experts in this case who rely on other people's work, to include Dr. Howard's work. But those experts are going to be testifying about their own opinions. Dr. Howard's work, his opinions cannot come in. It's just hearsay. Just because something's written in a report, just because something's provided to the defense, and just because something's given to another expert in formulating their own opinions, doesn't mean that everything comes in. Everything that comes into evidence has to comply with the rules of evidence. And this is rank hearsay. And this is litigated, and the court gave a ruling on this. We're getting close to sanctionable. I don't think the defense should be permitted to get into this, especially in opening statements. We have no way of knowing what evidence is going to come in. And this is something, again, it's just been litigated, and Mr. Johnson should be held to the rules to send me the statements. Thank you, Your Honor. Thank you, Mr. Johnson.
Thank you, Your Honor. Your Honor, it's, as mentioned, it's very clear from both our experts and state's experts that every single expert has reviewed the autopsy report and has made a conclusion on whether or not they agree or disagree with the cause of death. For instance, Dr. Desmond, defense expert, has reviewed everything, done the biomechanical engineering and all that. Detective Lalliton had a conversation with the replacement of Dr. Howard in January of last year, trying to see if there was anything different that they could find. And he did. Dr. Mott confirmed that the cause of death was gunshot wound due to the neck. That's why, frankly, I think it's disingenuous for the state 4 weeks before trial to change their theory, and why we wanted to
Let me get up there. That's not what we're talking about. This was the subject of a motion in limine, specifically that any opinion of Dr. Howard is the cause of death being gunshot wound, unless offered by Dr. Howard himself.
He's on calling.
Well, I granted the motion in limine, and I'm not allowing that until such time as that comes in as testimony. I think it's, at least as I understood from the motion in limine, it's debatable whether or not he ultimately is testifying that that ultimately is his opinion, and you cannot bootstrap it through other experts. Put his opinion in. Again, we had this hearing underlying on the arguments made at the motion at the time I granted it. So I'm sustaining the objection not to provide an opinion and opening statement.
We would take exception to the right, Your Honor.
Okay? All right, we'll bring the jury and I'll expect you to move forward with your opening without reference to Dr. Howard. You may be seated. You may continue, Mr. Johnson.
The evidence showed that Ms. Howard had a gunshot wound lodged in the C2. That bleeding was coming from the mouth. That the bullet went through the tongue. You'll see the gun. It's a .380, kind of a short, not like a normal gun with a long barrel. So the gun with a stub nose or short barrel that would not be able to go past the teeth and rest on the tongue. You'll hear that during the course of the investigation, Detective Valentin and others went up to Alaska to see if Mr. Howard was out of the affair. They didn't find anything. You'll hear about the affair that Ms. Howard kept secret from even her best friends. During the course of the investigation, there were a second search warrant done a couple weeks later, in February 17th. They go to the house, they examine various things, and then at this time, they send items to ballistics. They use Washington State Patrol, they have a forensic unit, to examine some of the evidence. During that time, Washington State Patrol found several key things. The gun had Kendy's blood on it, on one of the grips. It had her DNA on it, and another male's DNA. Dan was excluded from the gun. You'll hear that the coroner listed this as, initially, the photos that she had saved are called Howard suicide. Now, as the course of the investigation, Detective Valentin very quickly believed that there was something untoward about Dan. And that's based upon when Dan was finally, he was on 911 when officers showed up. At some point later in the morning, they let him start doing notifications. He called his son. He called Brooke, his stepdaughter. That phone call, you'll hear was short. You'll hear that right after that, a few minutes later, she called back. When she called back, naturally, she sounded upset, and Detective Valentin overheard that conversation. And from then, he specifically started accusing Dan who did this thing. And Detective Valentin conducted a couple of years of investigation trying to find Dan. At some point, officers obviously fill out police reports, detectives fill out police reports. The first time a police report mentions anything about a carotid restraint wasn't until April of 2023. Prior to that, Detective Valentin had a conversation with the replacement, Dr. Ma, a replacement for Dr. Howard after he had retired, to see if his opinions would be any different. It wasn't until after that sometimes in the police report there's a mention of carotid restraint. But you'll hear that there is no damage to the highway. There is no petechia. She just had her nails done. There is no DNA or samples from Dan under her fingernails. There is no defensive wounds from being restrained that Ms. Howard put on Dan. You hear that she took a bath every night. You also hear that night she had an iPhone, and it, like a lot of iPhones, it keeps track of your steps. You'll see that she went up before, do a nightly routine, took a bath. You'll see that at one point, about 10-11-ish, she took 43 steps. There's a wet towel in the bedroom. Her purse was now in the bathroom, where she normally kept the gun. 43 steps. The bath mat was wet, but nothing else around was wet. Just the bathroom. 43 steps. You'll hear that from one of the defense experts, that Dr. Deselman, that when he examined the evidence and the scene, that it is consistent. The body position, the mechanics, the gun placement is consistent with suicide. We talked about Bill Painter, Dr. Hanger. You'll hear about some of the things that would lead to suicide. Dr. Hanger will testify that a person who's trying to break off from alcohol is susceptible to suicide. You'll hear that she is not content with her body. She is struggling with whether she wants to leave Dan even after everything went down. In fact, what you will hear is that her brother and her got in a huge fight. The last text that Miss Howard sent was to her friend Tana about how her brother had blocked her because they got in a fight, brother. So during all this investigation, members of the state investigators, Ms. Marhofer, was going through the phones. While going through the phones, she came across a photo from about 7 months prior, from July of 2020. This photo has a large bruise that kind of trails up to the center. Also, she has bruising on her arm. It's limp. She had sent her paramour, her secret lover, Mr. Prado, and her friend Michelle messages around that time, and she never specifically says, Dan did it. But you'll hear that 2 other people were present, neighbors, who saw her when they were there, their neighbors, and they were loading up the boat to go to Dorchak. Dan and Kendy were loading up the boat. And she had slipped on the step that leads to the front of the boat where the trolling motor is. On the 10th of July, law enforcement was called. And you may hear that call, and you can make your observations about that call. But she's calling, and it's hysterical. I think Dan committed suicide. I heard a gunshot. Here, it is very common for Dan to fire guns, and he's a large parcel in Apple to fire guns. And so, I don't know if we'll have an answer why that was surprising. But law enforcement shows up, and she specifically denied any physical abuse. They are in Dorchak, and you'll see pictures of them at Dorchak. Loving, in a bathing suit, bruise showing. But that is the basis of the battery charge. During this time, Dan, for several years, has been working in construction. First in North Dakota, then in Alaska. He's working in the oil fields. 3 weeks on, 2 weeks off. Dan and Kendy were on the rocks. He came back 2 days late. He worked an extra 2 days. When they came back, they talked about divorce. They had stopped at Curly's. They then went home. And later that night, 911 gets a call. Now, she was on the phone with her lover, who then got in touch with her parents. You'll hear that the differences between those two, between July when she called 911 to where she was on the phone with someone else to have someone else call. Law enforcement shows up. Ken is not in dark clothing. He's in like these tan greenish khakis and a sweatshirt. Coincidentally, the same clothes that were in the washer a few nights later. Officers stay there. She packs a bag, a Victoria's Secret travel bag, and leaves. She comes back next day, brings beer and pizza. She spends the next 2 days, and they're filling out divorce paperwork. Ms. Howard is messaging her friends, saying he's being uncomfortable, or we're dividing everything up. And you'll see photos of the paperwork that is partially filled out. Dan goes down with Brian on the 1st, and then on the 2nd, they came back, and when they had a conversation, what's now on the paperwork is the new house. The house that was purchased is now on it. That was something that you'll hear about. What you'll see is Ms. Howard, when she was put in the body bag, they put bags on her hand to preserve for gunshot residue. They collected the gunshot residue. They sent it to the lab that they had the lab test it. We already talked about the DNA. The gun was not, the gun had someone else's DNA and her blood on it, but Dan is excluded from that gun. You'll see the blood amount. You'll hear that after a person is dead, the volume of blood will depend on a few variables, but generally blood will pump for, you'll hear around maybe a half second or a little more depending on the cause and manner of death. But the heart stops pumping. Also, the position of the body. You'll hear that. The person's lying down, the person's sitting up, the person's slumped. Where the injury is it below the heart, is it above the heart? Here, you'll see the blood. The injury was to intraoral. And you'll hear from both, all the evidence, most intraoral gunshot wounds are suicide. But the odd part is most intraoral gunshot wounds have an upward trajectory. Now, this one, everyone agrees, is an even or slightly downward trajectory. But again, this is a different gun. And you'll hear from Dr. Desmond that one of the scenarios is that she held it with her thumb on the trigger, which would lower that angle of the gun. She also, you'll hear, has bruising on this hand from the impact of the gun. You'll see that her hand position and the gun position is consistent with suicide. When you see all the evidence, and we've concluded this case, the evidence is not impossible and has not been eliminated. And therefore, we'll be asking you to find the defendant not guilty.
Thank you, Mr. Johnson. State and call us for witness.
Before that happens, Your Honor, can we excuse the jury for just 5 minutes? Put something on the record.
Okay. All right. We'll send you back out again. Just a few minutes. Might discuss the case among yourselves.
Your Honor, I'm growing concerned. I didn't object, but during opening statements, the defense alluded to this phone call and the belief that Mr. Howard may have shot himself, committed suicide. I do believe that's the topic of some pre-trial litigation. I believe there's a ruling on that. And the reason why I'm growing concerned is because twice now, during opening statements, the defense has disregarded court rulings. And this puts the state at a severe disadvantage. If I were doing that, this would be prosecutorial misconduct. But yet, this attitude that, well, I'm the defense attorney, I can get away with it, what's going to happen? It's going to be a mistrial. Maybe we'll have to do this some other day. That attitude cannot be tolerated. The state has no remedy here except to ask for sanctions or to file a bar complaint. The court can file a bar complaint. I'm asking the court to admonish the defense to adhere to prior court rulings. The state is entitled to a fair trial just as much as Mr. Howard. And so I would ask the court to address that before we get into evidence. And this can't wait until whether or not the defense puts on a case in chief. The defense gets to ask leading questions on cross-examination. If Mr. Johnson is going to build hearsay and inadmissible evidence into his questioning of state's witnesses, the jury's going to hear that before I get to object. And again, Your Honor, if this is going to be the attitude moving forward, or Mr. Johnson's tactics, the state is at a severe disadvantage. So I would just ask the court to please revisit with the defense prior court rulings and admonish them to follow those orders. Thank you.
Mr. Johnson.
Well, I guess first I'd like to be a little more specific of what he's referring to, because if he's referring to Detective Alton having a conversation during the course of the investigation, I did not refer to what Dr. Mott said, number one. I referred to a conversation that the Detective Alton had. That's within the scope. There's not been a pre-trial motion on that. I don't think Dr. Mott himself has come up with a pre-trial motion. We did not give an opinion or refer to an opinion of Dr. Mott. I referred to Detective Alton's actions. He called, or had a conversation with Dr. Mott regarding whether he disagreed with the autopsy. That's not subject to a pre-trial ruling. That's fair game and cross. That's an appropriate question. And if the answer is different than what I presented, then I look bad if he did have that conversation. But we know he did because we have a police report.
I'm not sure that's what the concern is. I think it was maybe you can spell it out, but the references to,
Sure.
and I thought the pre-trial ruling, I think it's actually Judge Meyer's pre-trial ruling, was that the gunshot that caused Kendy to call the police, it wasn't clear that it was a gunshot, and the state was prohibited from referring to this as a suicide attempt. And then you just opened that door wide open by referring to it as, well, this wasn't suicide, why should call the police? So I don't know that it's sanctionable as much as it just opens the door for the state to talk about it as they, they're not bound by that pre-trial ruling anymore. So if you want to open that door, you did. So I'll say the state's no longer bound by that pre-trial ruling. That prohibits the state from talking about it. I'm a little concerned, maybe not to the same level of the state's argument, but that we had extensive extensive pretrial motion practice and rulings. A lot of those were oral rulings, just given the amount of time and trying to get them done, but I at least reduced them to writing in terms of like granted, denied, et cetera, so everyone would be able to refer back to it. And so I do expect parties to follow that and apply by the court's rulings on those things. Ms. Warren, am I correct that that's what you were referring to?
Yes, Your Honor, there was 12 B motions, and there was a written order from the court, and it was specifically regarding suicide attempt that I mentioned on that phone call. So,
I think it was the state wasn't referred to that as a suicide attempt or talking about that, but I would say that door's wide open.
and again, this is the attitude, well, that was the defendant's motion, and the defense is fine if that door is open now. That's a poor attitude to have in trial. It's evidence of disregarding the court's order. Yeah, again, if I had that attitude and I was opening doors that shouldn't be open, if I was disregarding court orders, we'd be talking a much different conversation right now. I would just like to point that out, Your Honor.
All right. Okay, let's bring the jury back up and proceed with the jury. You may be seated, thank you. Cindy calls first with us.
It's Kendy Howard.
Thank you. Board, sir, please step forward, please state the record, raise your right hand, please swear.
Do you solemnly swear that the testimony you're about to give in this case shall be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, I do. Thank you, sir. Welcome, Madam Secretary. Your name, Clark?
Thank you, Judge. Can you say your whole name and spell your last for us?
Kenneth Charles Lallington, L-A-L-L-A-T-I-N.
Mr. Loughton, what do you currently do for work?
Well, I am currently working for Olo Builders, which is a national home building company. I was recently hired to manage their local office.
Before that, how were you employed?
With the Kootenai County Sheriff's Office as a detective sergeant,
At some point, you retired?
I did,
When was that?
September of 2023.
Can you describe for us your law enforcement career before you retired?
Over the last approximately 18 years, I've worked in the detective division as a detective sergeant, investigating and supervising major crimes and crimes against persons, to include investigating death scenes, suicides, homicides, suspicious deaths, crimes against children, sexual assaults against adults, and I was also a member of the unit that investigated officer-involved shootings and other incidents of that nature, as well as one of my other responsibilities was to investigate and conduct internal investigations when there was accusations of wrongdoing by other police officers.
In the Sheriff's Department, what did you do before that?
Well, before that, then I worked in the patrol division as a watch commander. Before that time, I was a supervisor in the backcountry Marine Division, and before that, I worked as a narcotics officer with the Joint Drug Task Force.
And before that, you worked with another law enforcement agency.
I worked for two.
Can you describe this?
Prior to Kootenai County, I worked for the Boundary County Sheriff's Office as a patrol deputy for a couple of years. Before that, I worked for the Kootenai County Sheriff's Office in Casper, Wyoming.
So how many years total do you have with law enforcement experience?
Approximately 30 before retiring.
On February 2nd of 2021, did you become involved in the case involving Dan Howard?
Yes, I did.
Is he here today?
Yes, he
Can
is.
you please point him out, describe where he's seated, tell us what he's wearing?
Mr. Howard is seated at the defense table. He's closest to the jury. Gray jacket, light colored, possibly pink shirt.
Was this your case to begin with?
No, it was not.
Whose case was it?
It was Detective Sergeant Darrell Wheeler.
Ultimately, did it become your case?
Yes,
Why is that?
because Sergeant Wheeler retired from the sheriff's office.
Nonetheless, were you active in the investigation even though it wasn't yours to begin with?
Yes, it was.
When you arrived at the Howard's residence, about what time was it?
I believe Sergeant Wheeler and I arrived at the residence about 1:45 midnight, 15 to 20 minutes before midnight.
Were you called out from home?
I was.
And was he as well?
Yes.
When you got to the Howard's residence, was there other Kootenai County Sheriff's Department people there already?
Yes.
Describe that.
Detective Jerry Northrup was parked outside the residence on the road awaiting our arrival. And at the residence and inside was Sergeant Severin, who was a patrol watch commander, and approximately 5 other patrol deputies.
Are you familiar with the Howard residence?
Yes, I am.
Can you tell us what the address is?
30267 North Wheat Ridge Road, Athol, Idaho, Kootenai County.
Have you been there before?
I am.
Are you familiar with the layout of the home
Yes, I am.
and the ground surrounding it?
Yes.
Let me show you some exhibits. They've been marked as 1, 2A, and 2B. I'll hand them to defense counsel first of all. Ask you if you recognize 1A and 1.
Yes, I do.
Do you recognize that?
That is an aerial photograph of the Dan Howard property on North Wheat Ridge Road.
An accurate layout of the buildings on that property?
Yes, it appears to be.
And the next two have been marked as 2A and 2B. Take a look at those, starting with 2A. We recognize that.
That appears to be the floor plan of the main level of the Dan Howard residence.
And so by floor plan, you're referring to rooms, walls, closets, beds, furniture, that kind of thing.
That's correct.
And then 2B?
That would be the basement area of Dan Howard's residence at 30267 North Wheat Ridge Road in Athol, Idaho.
Okay, again, showing the same items that 2A had.
Yes,
Does this appear accurate in terms of the layout of the furniture of the house was back in February 2nd, 2021?
so that's my recollection, yes.
You have to admit, 1, 2A, 2B,
Exhibits 1, 2A, and 2B are
the published statement.
you may publish.
Okay, we're looking at 1A. So it looks like North Wheat Ridge Road is the access point to the Howard residence. Is that accurate?
Yes.
Is US 95 close by?
It's several miles to the east of this location.
And looking down here, describe what we're viewing.
I'm going to use this.
Yeah, if you don't mind.
You can show me how to get it to work. Oh, there we go. So what we see here is down below, which is not in view of this particular photograph, is Highway 54 that runs east and west between Athol and Spirit Lake, Idaho. This right here is North Wheat Ridge Road, which runs north and south. And this is the property line, approximately, of the Howard residence. As you enter the main driveway, you have the residence to the left. This is the garage, and this is the main house here. There's also a shop located right here, and there are several outbuildings just directly to the west, or I guess northwest of the residence.
Okay. And then if you could do the same with 2A.
So if you enter the residence through the garage, which we did that evening, there's a man door right here that enters into the kitchen, dining room area. Then there's a living room with some furniture. There's a couch, a chair, I believe, right there. And then you can go downstairs. From there, it's a split level style residence. And to the left is, oh, I'm sorry, actually. So on here, on this particular drawing, you go upstairs to the residence. To the left are a couple of bedrooms. To the right is the master or primary bedroom with its own separate bathroom. And directly above the stairs going up is the other bathroom.
Before I show you B, I'm going to ask you a few more questions about that night and 2A. So when you and the other detectives arrived, did you end up waiting there for a lengthy period of time?
Yes, quite a while.
Like how long about?
From the time we arrived there, I would say we were at the residence total probably a good 8.5 hours, maybe 9 hours.
And what was the reason for much of that delay?
Waiting on the search warrant to arrive.
When you got there initially and you went through the garage and you go into the living room, tell us what you could see.
Well, when we arrived, we entered, I don't know, can you see that?
Yeah.
We entered through the open garage door, into the main door. When I walked in, I could see Dan Howard's seated in the living room area. There were some deputies in the residence. We were then directed upstairs, where in this main central bathroom, I observed, quite later, well, who I recognized to be Kendy Howard.
So you had met Kendy Howard prior to this date?
Yes.
And was Kendy Howard in that bathtub as depicted in 2A?
I
Or at
would
least
say-
approximately.
I would say that's a reasonable diagram.
Okay, and was she deceased?
She was.
Okay, after viewing Kendy, did you go back downstairs?
Yes.
Ultimately, did you, at some point, become familiar with, not the main floor, but downstairs?
Yes.
What was depicted in 2A? I mean, excuse me, 2B. We'll take a look at that briefly, and maybe you can do the same thing that you've done with the other exhibits with that.
Now, this doesn't seem to be working.
To get to this downstairs room, we're simply taking the stairs down.
Yes, like I said before, it's a split level residence or tri-level.
This would be the,
This would be the basement, so you go down to the left of the stairs. So when you get to the stairs, you have a choice on the main floor going right upstairs or to the left downstairs. If you pick the left and you go downstairs, to the left and kind of straight ahead is a laundry room. There's a bedroom down there, and to the right is another family room area with a wood stove and a bar area. There's a couch, some chairs, and I believe a television down there.
okay, I think that does it for those exhibits. Let me ask you a couple of questions about any objects that you could see in the bathtub with Kendy. Were there any?
Yes, there was.
What was it?
Most notably, I saw or observed a handgun to the right of her, laying at the bottom of the bathtub, and there was what appeared to be a spent shell casing on the bottom of the tub between her legs.
Was there still water in the bathtub?
There was water.
About how much approximately?
I couldn't tell you exactly right now how much was in there.
Were you able to see through this water and view those objects without taking them out?
Oh, yes.
Did you and Detective Euler end up waiting for that search warrant, and then during the time the search warrant was executed, having a very lengthy conversation with Dan Howard? I guess it would be the early morning hours of February 3rd, 2021.
Yeah, I wouldn't necessarily categorize it as lengthy because we took some breaks in between while we were waiting for the search warrant, but yes.
Was it recorded?
Yes, it was.
And who recorded it?
Detective Sergeant Darrell Euler.
How?
Using a body camera that had both video and audio.
All right. During the entire time, essentially?
Yeah, as far as I know, during the entire contact with Dan Howard, yes.
Okay, so those recordings are with you.
They are.
I just want to ask you some specific questions about that conversation that you and Detective Euler had with Mr. Howard. We're going to watch those recordings next week at some point, okay?
Okay.
All right, so I know you told us that you've met Dan Howard before. Have you talked with Dan Howard before?
Yes, I have.
Is Dan Howard the kind of person that looks you in the eye when he speaks to you?
Yes.
Would Dan Howard look you in the eye early that morning?
Objection, foundation.
Lay a little bit more foundation about his interactions that would lead him to make that foundation about.
How many times have you spoken with Dan Howard since you've known him?
Probably a couple.
When was the last time you had a conversation with Dan Howard?
Prior to this evening?
Yes.
Would have been probably 10 years before this.
And what was your relationship with Dan Howard back in 2014?
Objection, immediate withdrawn.
Okay. Sidebar.
The other times that you talked to Dan Howard were when?
Prior to that 10 years?
Prior to
Prior.
February 2nd, 2021.
It would have been about 10 years prior.
Okay. And about how long were those conversations that you had?
They're fairly lengthy.
So you've had substantial contact with him in the past, face to face?
Yes.
And in those prior contacts with him, would he look you in the eye?
Objection, found.
Yeah.
What, would he do that when you were talking to him on February 3rd in the early morning hours of his house?
No, not consistently.
What do you mean by that?
During our contact that evening, Dan made very little eye contact with me.
At times, did he make eye contact with you?
At times he did,
And,
yes.
and what was his emotional level at the times he made eye contact with you, during the times that he did that morning?
I would say he appeared to be frustrated or trying to explain something.
Objection, speculation.
Did you ask him initially what had been going on between him and Kendy?
Yes, I did.
What did he say?
He indicated that they had been having some problems.
Did he indicate to you whether or not they were speaking of divorce?
He did.
What did he say?
He said that they had been talking about divorce.
Did he give you a reason that he thought Kendy killed herself?
Yes.
What was that?
His reason that evening, explaining to Detective Euler and I, was that during the divorce paperwork that they were filling out, or he had filled out, he wanted to include a residence that she had made an offer on down in Kootenai, Idaho, and that she got very upset over the fact that Dan wanted to include that in the divorce.
Was this just simply a residence that she had put an offer on,
That's correct.
that she had not acquired?
And she did not acquire it, no.
And after or during the part where he gave you that reason that she killed herself, what did he tell you was the chain of events that occurred in terms of later on in the night? Did he indicate to you that she went up and took a bath?
Yes, he did.
And then?
That later at some point he heard what he described to us as a thud.
Okay.
He continued to fill out some paperwork, work on the paperwork, have a beer or several while watching television and doing some laundry.
Did he give you a time frame in terms of hearing the thud upstairs and him going to check on Kendy?
Ultimately, he estimated between 1 and 1.5 hours
And what did he say he saw when he went upstairs to check on Kendy?
that he found Kendy in the bathtub unresponsive.
And did he describe to you the condition or temperature of her body?
Warm. I'm sorry. Actually, he told us that she was cold to the touch.
At some point in your conversation with Mr. Howard, did you ask him whether or not he had shot a firearm that day in conjunction with GSR testing?
I didn't ask him those terms.
At some point, did you use a ruse in speaking with Mr. Howard that involved gunshot residue testing?
Yes.
Why?
I wanted to see what his reaction was going to be.
Why?
Because at that point we were all suspicious of the circumstances of Kendy's death.
What is GSR?
It's known as gunshot residue, and it occurs when you fire a weapon and you're in close proximity to it. It's basically what's been described to me by scientists and experts. Response?
Well, I think he's just explaining his general understanding of the term.
Well, this isn't offered to definitively define it for the jury, but just his understanding of what this testing involved.
So GSR is the powder and residue when you fire a gun. It's fine like flour, and it sticks to pretty much everything in proximity to that firearm when it's shot.
And is it something that you've utilized in your career?
Yeah, I have in the past early on, but it's not something that we've used for many years.
Why is that?
Basically because it's described as junk science.
Jackson, here's.
Yeah, it's just why he doesn't use it anymore. It's not for the truth of the matter, sir, Judge.
Okay, I'll limit that for the jury, that he's not testifying as an expert as to gunshot residue, he's just explaining why he no longer uses it.
To your knowledge, will any state lab in the country accept GSR testing?
Not one that I'm aware of, no.
Later on in the interview, did that topic of GSR testing or that issue come up in terms of whether or not he shot a gun?
Yes.
Can you run us through that, please?
I asked Mr. Howard if there was any reason he would have GSR on his person, on his hands or his body.
His response?
After a pause, he indicated that he had shot one of his handguns earlier that same day. Approximately, I believe, between 3:30 and 4 o'clock, somewhere around there.
And then did you and other detectives take some steps to actually engage in GSR testing?
Yes.
Why?
Because I had mentioned it, basically. And so one of the other detectives on scene went ahead and swabbed him for GSR.
Did that provoke any responses from Mr. Howard that caught your attention?
Yes, it did.
Describe that.
As we were all standing out there in the driveway of his residence, he had shoved his hands in his front pants pockets and were shaking them, rubbing them back and forth in a very fast manner. To the point where one of the other, Detective Euler had to ask him to stop doing that.
At a point in the investigation, did you allow Mr. Howard to tell his family about what had happened earlier in the night?
Yes, we did.
About what time do you think that was?
I believe it was after 6 a.m. approximately.
Why had you waited so long?
Well, when we were waiting for the search warrant to get there, we didn't want any additional family members showing up on scene, and we don't have to deal with any other issues. We didn't know what the state of their mind was going to be.
Were you there when he called family members?
Yes, I was not there for the initial first, I believe, two, but I did witness and observe at least one of them.
Which one was that?
That would have been with his stepdaughter, Brooke.
When he called Brooke, were you there?
No, I believe he was downstairs with Detective Oyler at that time.
When she called Dan back, were you there?
Yes, I was.
And were you there to hear whatever you could hear over the phone from her?
I could hear it from across the room.
And were you there to hear his responses?
Yes, I was.
Who spoke first when she called Dan?
I don't recall who spoke first. I believe it was probably his stepdaughter.
Can you describe the conversation for us to the best of your memory?
She was angry, she was upset, and she immediately accused Dan of killing her mother.
And Dan's response?
He was visibly shaken and upset and denied it.
Anything else to that conversation?
I mean, that was the gist of it. She accused him, and he denied it, and from that point on, he was pretty upset.
So this investigation, can you kind of give us general outlines of it? Did it involve execution of search warrants?
I guess it did, quite a few.
About how many and what sorts of businesses or institutions?
Well, we did an initial search warrant that evening. There was a second search warrant at the residence later, approximately almost 2 weeks later, I believe. And then from that point on, there was at least 12 to 15, 16 more search warrants that were written to various locations, banks, Idaho State Tax Commission, Percy, Kootenai Health, places of that nature.
All right. Places where there would be records involving Dan Kendy?
That's correct.
You were obviously working with the investigation, and the coroner came back with the undetermined on the autopsy.
I don't think I was actually still personally involved in the investigation during that time frame.
When you became involved in it, were you aware of that undetermined by the coroner?
Yes, it was.
Did the investigation, at least from your perspective, when you took it on, continue?
Yes, it did.
Why?
Well, because one, the initial response to the scene, the incident that took place on the 29th prior to Kendy's death, Dan's reaction that evening, observations that were made not only by myself, but literally by every other officer that was on scene that night, the inconsistent statements from Dan that evening, the inconsistent, basically, crime scene or death scene where Kendy Howard was located. There was concerns about injuries located on her person and her body that were also not consistent whatsoever with what Dan had tried telling us earlier.
In the investigation, after search warrants were executed on various banks and the assessor and things like that, did the sheriff's department develop a possible motive?
Yeah, yes we did.
What was that?
Couple of things. One, anger over Kendy's affair, and probably the bigger one was the money.
Did the investigation go to the area of Kendy's mental health at that time?
Yeah, absolutely. That was taken into account from day one.
And was that a consideration in this investigation going forward, even though the coroner had ruled it undetermined?
Yes, it was.
Why is that?
Well, because we had to rule out that she didn't commit suicide, that she wasn't suicidal, that she wasn't depressed.
That's your foundation.
I understood that was, you're asking why they continue investigating.
Correct.
So I'll overrule the judge.
No further questions.
Thank you. Cross-examination, Mr. Johnson?
Let's get that break order.
Sure. The jury's been out a few times, but you all haven't been, so we'll take a 5 to 10 minute break for humanitarian purposes. Maybe recess. Remind the jury once again not to discuss the case among yourself or one of any aspects of this. All right, let's be back in 10 minutes.
Do you want me to do it first or you? You're locked and loaded, so I'll just and it's waiting, so okay, great. Yeah, mine's the same. Like you're recording such a long thing right now.
Here's your pulled up. Here.
There's long chunks. Like I usually go like one long clip, but like there's clips because of the breaks and injuries issues. So you guys are ready tomorrow? Oh, the rest of the week. I know Gately will be cool, but I don't know when. Is that the right path for it? No. Can I just, yeah, you can.
3 years, 5 years. Well, we did that, and then so.
Yeah, April probably think of it now. Just like now that we're done with the year, like bring the boxes. Yeah, once you guys have a great setup too. Yeah, yeah. I just today was kind of boxes. That's not like a box with like the games. Yeah, because Alyssa's camera's the same as. I don't even. Can you do the box? She's talking about like the splitter for the video cable. Gabe just keeps going. Gabe for sure.
Yeah, I can bring one for your station.
Yeah, so Gabe's our chief. He was at the Gary trial.
Just so it doesn't die.
Yeah, so we'll be. I think Paul said Wednesday this week, but it'll be pushing tomorrow. I think we're tomorrow Wednesday. Oh, yeah, I'm not sure. I'm assuming usually when we do pool,
Probably should be fine.
but I don't know.
I mean, it's like
Okay.
It's like 10%.
But no, we'll be coordinating all of that, so he'll probably be on Thursday. Okay. Just in case if I need you to routine that. Okay.
Just like wanted to find me
Yeah.
today because I've literally
I'll
charged
talk to
twice.
him. I'll text him now, say, hey, can you coordinate for the rest
Oh,
of
wait,
the
does that have like, does it have like this type of plug-out? Like to do the box? Oh my god, wait, yeah.
I'm the chief.
Oh wait, no, yeah.
Every day.
Thank you.
Everywhere, so.
But you're on record.
Yeah.
Out of town for career fair this Friday.
Yes.
Yeah.
Yes. And I tied. Because I'm okay with
All the career fair days.
I am.
Bringing an extension.
Alright.
Cable because we have.
I have to head out though after.
Okay.
Right.
And an extension. Power strip for like.
Yeah, no, everything's basically already written. Like, yeah, well, with life aside, but then, yeah, package or whatever. So, it'll be. No, we only have 5. Well, we do have an 11, but we write like just a VO of those odds, yeah. But no, they don't rerun the packages or anything. Yeah, I know. I'm sure that's again.
Getting there. I had to do it in like 2 batches because sometimes when we do it like all together, it says like there's not enough space. But when you do it separately for whatever reason, it's like, you know what, there is enough space. These are non-structurally sound. Yeah. Yeah, exactly.
They edit it for you.
She'll be editing it for me.
Laptop editing fun.
One time, oh no, I'm doing a thing yet, like when the previous hall just lost power. Somebody had a power line, and they lost it for like, I think they had like, wait, it's here? Not here, it's by Moscow, actually in Moscow as well, and in Pullman. Construction workers hit it, and it's a power line. I think it was like tens of thousands of people lost power. And it was, I had to turn it back, and it had 33 minutes to turn it back. It was like a remote edit. I was like, this is, how could you even do that? Power gone. Well, we had our own power thing, but going live, I was like, I sent my script back to the office, and I was like, can somebody please look at, like, I literally went live in 3 minutes. This is already drafted. Like, just, I rewatched it, I'm like, at one point, there's like a pan. I was like, okay, thanks.
The adrenaline of it all.
Chest pains. Laptop editing, though.
Okay, Brett. See scratch cutting on it from years too. Like I can just, it's just too much. It's like
You say I make you nervous, a tragedy, I'm a beautiful disaster, a reckoning. You wonder how I got this way. You think I'm someone to be saved, someone to clean up.
Hello, all. Quick little break here.
Sorry, I said 10 minutes and then something else came up and just, all right, cross-examination is a
Hey, John. Good afternoon.
Then,
So, how long did it take you to become a detective?
From the time I started my career, it would have been 93. I was a narcotics detective in 99. And then had a break and went into major crimes in 2000. January 2006.
Is there, what kind of, were you a patrol officer before that?
Yeah.
What kind of different things did you have to learn from being a patrol officer to become a detective?
Well, there's all sorts of things. Various classes, basic academies for detectives, advanced academies
For detectives.
for detectives.
This stuff that patrol officers don't do.
It's open to most patrol officers, but many don't attend.
And is there a difference between, say, investigating, being a narcotics detective? Do you learn different things from being a homicide detective or a major crimes detective?
Well, the basic concepts of investigations is really the same. But yes, the nature of the investigation is different.
How much training did you have to go through, starting with the narcotics detective? How much training did you have to do to become a detective?
Well, I didn't necessarily have to do any of the training to become a detective. It was an appointed position.
Okay, but to stay a detective, you had to complete training?
Well, every police officer has to do so many hours of training every year to keep their certifications.
Okay, let me rephrase. How long did you take in hours or coursework to become as a detective before you retired?
How many hours of training did I complete during my time as a detective?
Yes, ballpark.
I would say anywhere from probably 750 to 1,000, and that would be a real rough ballpark.
Hours?
Yeah.
Okay. And in there, is it fair to say your knowledge of a crime scene and the investigation that goes into it is more extensive now than when you were a patrol officer?
Oh, absolutely.
In part of your investigation, you pulled Mr. Howard's records as one of his former law enforcement, correct?
I'm sorry, I couldn't hear that last part.
As part of your investigation, one of your search warrants was to receive the records for Mr. Howard's time at the police force?
Yes, I did serve a search warrant on Idaho Post and obtained all of his records.
Patrol Officer Howard was never a detective, correct?
That's correct.
You don't have any record of him attending crime scene homicide investigation, correct?
That's correct.
Now, in your extensive training and experience, you're taught to fill out police reports.
Yes.
You're taught to include all relevant information as it relates to your investigation.
Yes.
So in this case, there are, with all the different officers, there's 46 supplements to this police reports, ballpark.
I would say that's pretty close or accurate depiction.
And, for instance, supplements 31 through 46 are all yours, correct?
All but one, I believe, yes.
And so when you fill out, for instance, a search warrant for Bank of America records, you might wait till you get those records back and then fill out one report that encompasses both days, right?
I don't understand what you're asking.
Meaning every phone call or every day is not necessarily a separate report, correct?
No.
But everything that's relevant, you include.
Yes.
Okay. You filled out a police report of your interactions with Mr. Howard on the morning, early morning into the morning of the 3rd of February, 2021.
That's correct.
In that police report, you never mentioned Mr. Howard having issues with him looking at you during your conversation, correct?
No, I don't believe I put that in my report.
In your police report, you never mentioned Mr. Howard supposedly putting his hands in his pockets and robbing him, correct?
That's correct.
Now, did you participate in the first search warrant?
As far as processing the scene?
Yes. Okay. Who processed the scene to your knowledge?
Detective Jerry Northrup was in charge of the processing the scene, and Detective Chris Hersman assisted him.
Okay. Now, there was a second search warrant conducted on the premises in February that same month.
That's correct.
Were you present there?
Only for portions of it.
Okay.
I, again, did not participate in the actual processing of the scene.
What search warrants did you apply for?
Well, I don't have the list in front of me. The ones I applied for would have been, on top of my head, it would have been some bank records. It would have been bank records, Percy, that would have been Dan Howard's retirement information. Would have been Kootenai Health for Kendy Howard's employment and insurance information. There was several different financial institutions. Idaho Post. I'm sure there were some others.
Now, you and Detective Northrop went up to Alaska together?
No.
Was it you and one? You and Detective Weather went up to Alaska. And part of what you were looking for was to see if Mr. Howard was having an affair?
That was part of it. There was more of it.
During your conversation with Dan, there was mention of him coming home a couple days late,
Yes,
and your understanding from the conversation was that he worked a couple days late, a couple days over.
that's correct.
You confirmed that he did in fact work a couple days late up in Alaska, correct?
Yes, we did.
During that time, also, in your police report, you say that his coworkers didn't have anything of evidentiary value or significance.
Correct.
Did any of them describe seeing Dan as sorrowful?
I don't recall that, no.
Now, in the course of your investigation, what other things did you interact with some of the experts of the state in this case?
Yes.
Did you interact with a Dean Livingston?
I don't believe I did. Not that I recall.
And during this course of, so to the timeline-wise, do you have your reports?
No.
Okay. Are you familiar enough with the timeline that you're able to answer ballpark dates?
I think so.
Okay. So early on, a decision was made to send items of evidence to Washington State Patrol, correct?
That's correct.
That was probably to avoid, since Mr. Howard had previously worked for ISP, as to avoid any perceived impropriety.
Yeah, but I feel it's necessary to let you know that I was really not part of that decision-making, as I was not in charge of the investigation at that time.
When did you become lead?
Wasn't until after July of 2021.
And did you review all the reports and emails and correspondence in the file for the few months prior to you taking lead?
To the best of my knowledge, I did.
And did you review the evidence that came back in this case?
I did.
In fact, somewhere around August of 21, you did an evidence review where you went and looked at the physical evidence.
That sounds about right.
After that time, so sometime in September, you obtained a warrant for Kendy's optical records.
Yes, from Costco.
Okay. And after that, so this is now 7 months removed from her passing.
Correct.
And in 22, the year 22, what did you do as lead investigator in this case?
During the entire year?
What steps? You just hit the major milestones of what you did in 22.
Well, without reviewing my reports, I couldn't sit here and tell you exactly everything that I did during that year.
Okay, so you filed for a warrant for medical records for Ms. Howard in December of 2021, correct?
Say that again?
You filed for a warrant for Ms. Howard's records in December of 2021.
I believe that's correct.
And that's the type of thing that you would fill out a police report for, correct?
Yes,
And you did in this case.
I believe I did, yes.
The next police report that you filled out is in August of 22, correct?
That sounds about correct, yes.
Okay. And that was where you go to the medical examiner's office in Spokane and review the tunnel.
I believe that was 23.
Okay.
You said 22?
Well, 8/23/22.
Yeah, I believe that was in August of 23.
So after he was charged?
I'm sorry?
After he was charged?
No, I'm sorry, 22.
Okay.
Correct.
So August 22.
Yeah, I've been retired for a while.
So between December of 21 and August of 22, there's no police reports that you filled out, correct?
That's correct.
What did you do to investigate during that time?
Well, during that time, I was working on the cases for one thing, I had other responsibilities,
Okay.
and it was during that time frame, we were waiting for information to come back, and we were also working with various expert witnesses.
Okay. When you say we, you were working with them?
Myself and other investigators that were still involved with the case.
Which witnesses were you working with?
Dr. Ram Barron, Dr. William Smock, and Dr. Jennifer Nara.
What made you, after August, the next police report you have is in January 23, correct?
I believe that's correct, yes.
And that was a search warrant for a different bank records, correct?
Yeah, I believe that was the one out of County.
Then, also, that month, you filled out a police report in January of 23, where you had a phone call with Dr. Mott, correct?
Is that January of 23 or 22?
January 23.
Yes, that's correct.
And the purpose of that phone call is Dr. Howard had retired at that point, correct?
Yes.
Was it your understanding? What was your understanding of what were you trying to have him review?
Well, him as a her, Mackenzie Mott is a female. And I believe Mackenzie Mott called me as a follow-up. What we're looking for is there was concerns and inconsistencies with the original autopsy.
Okay. And those concerns were your concerns?
They were made my concern, yes.
And then after that, in April, you filled out a police report where you mentioned in the course of an interview a carotid restraint, correct? That's April 23? A carotid restraint?
I believe so, yes.
That's the first time in a police report that you have mentioned carotid restraint, correct?
That's right.
Now, going back to the day of Kenny's passing, when you were there, Mr. Howard was watched by Deputy Wheeler the whole time, correct? Do you understand?
I don't know if it was strictly Deputy Wheeler, but he was generally in the presence of one of the officers while we were there, yes.
So you, Detective Euler and Detective Northrop, you come in and out at different times, but you're also calling Detective Hollenbeck, correct?
No,
Okay. You're checking on the status of the warrant?
yes.
And Detective Hollenbeck, 511, okay. We'll get to that. The warrant, but while you were out there were other officers. How many officers were present now?
Well, when we first arrived, I believe there was 5 or 6 officers on scene. Not all of them were in the house. There was 5 or 6 there. As the evening went on, some of those officers left. So we had 1 or 2 there, I believe.
Okay. Now, when you overheard Kenny's daughter emotional on the phone, you accused Dan of killing his wife, correct?
Yes, I did.
That's when you made up your mind?
No.
No further.
Thank you, Mr. Johnson. Redirect, Mr. Berger.
Thank you. Council asked you about in any of your reports that you mentioned, specifically one of the ones on February 2nd, whether or not Mr. Howard was looking at you in the eye. Remember that question? Like,
Yes.
And you said, no. Why is that?
Why did I say no? We
Why
wasn't?
didn't you mention it in your report?
Well, one, Detective Wheeler was also filling out a report on that. And the other part of that is the entire contact was captured on video.
You also, in talking with council, mentioned that every law enforcement officer, every post-certified patrol officer in Idaho has at least so many hours of investigation. Is that accurate?
Yeah, every police officer has so many hours of investigations that they receive at post.
Can you give us a little more detail about that?
Well, it's basic training in investigations. Some agencies, like Idaho State Police, has additional investigative academy that they attend that is solely pertains to investigations.
You patrol officers, you train in the basics of DNA,
Yeah,
fingerprints,
yes,
ballistics.
yes.
Council also asked you about your report and whether or not you had mentioned that Mr. Howard put his hands in his pockets and vigorously wiggled them after he was braced at the GSR topic. Remember that question?
Yes,
Was there another deputy, nonetheless, that did document in his report?
yes.
Who was that?
Detective Darrell Boylan.
No further questions.
Thank you, sir. You may retake your seat. Next witness.
Janice Wadsworth.
Sorry, I can't quite hear you.
Janice Wadsworth.
Thank you. Good afternoon, ma'am. If you come forward, I'll have you face my clerk. Please raise your right hand and be sworn.
Do you solemnly swear that the testimony you have to give in this case to be the truth, the whole truth, and nothing but the truth, so help you God?
Thank you. Do you have a seat right there? Ma'am, as best you can, I'll just have you scoot forward a little bit. Make sure you talk to the microphone. You make Margaret sworn? Forgive me, was she sworn in? She's sworn in, but I haven't got her name for the record.
Ma'am, could you please state your name for the record and you spell it?
Janice Wadsworth, Janice,
W-A-D-S-W-O-R-T-H.
And ma'am, how are you employed?
I work for the Cook County Sheriff's Office as an emergency communications officer.
Is an emergency communications officer often referred to as a 911 dispatcher?
Yes,
Okay. And how long have you been employed in that fashion?
over 7 years.
And were you working as a dispatcher on July 10th, 2020?
Yes.
And could you please tell the jury what exactly a dispatcher does?
I answer 911 calls and active calls, dispatch law enforcement, fire, and medical throughout Kootenai County.
Okay, so as a dispatcher, these 911 calls come in, and you said you answer calls for different agencies, like police, paramedics, fire. And when these calls come in, do you work with a software system that helps you?
Yes.
And what is that software system called?
It's called CAD, computer-aided dispatch.
So CAD is C-A-D, Computer Aided Dispatch. And are you able to, when you're on the phone with a 911 caller, how are you using CAD?
I answer the call in for the responders, entering the address and the details of the call for them to see on their computers as well.
Okay, so when you're on the phone with a 911 caller, you're putting notes into CAD?
Correct.
And you said it's for the responders?
Yes.
And who are the responders?
Law enforcement, fire, EMS, whatever.
Do law enforcement, fire, EMS responders have CAD in their vehicles?
Yes.
So this CAD system, are they able to read your notes as you're putting them in while you're on 911?
Correct.
Okay. And so while you're on the phone with somebody calling 911, you're in constant communication with responders?
Yes.
And while you're at work as a dispatcher, you're using CAD, do you have anything else at your disposal that you can record in the 911 calls?
Yes.
Is that CAD or is that something different?
There's different programs we use, but the phone calls are recorded as is my screen and everything.
Okay, so the audio of the 911 calls, did they get recorded as well?
Correct.
Okay. And does that system, any of the systems you use record the date and the time of the 911 calls?
Yes.
Okay. When you were working on July 10th, 2020, were those systems all working?
My own, yes.
And did you receive a phone call, a 911 call on July 10th, 2020 from a Kendy Howard? Okay. And do you recall what time of the day that came in?
After 9 p.m.
9 p.m. about? Okay. And have you had a chance to go back and listen to that 911 audio? Okay. May I approach, Your Honor? You may. Now, I'm showing you what's been marked as Plaintiff's Exhibit 4A. That's a CD, correct? Are you aware or familiar with the contents of that CD?
Yes.
And what is that?
This is the 911 audio of the 120 witness.
Okay. And have you had a chance to listen to that?
Yes.
And is it true and accurate to your knowledge?
Yes.
And I'm going to go ahead and talk to counsel real quick. Now, I'm going to show you what's been marked as Plaintiff's Exhibit 4B. Are you familiar with that exhibit?
Yes.
And what does that appear to be?
This is the, I'm sorry, I'm going to say script, but I don't know if the wrong word.
Transcript?
Transcript, yes.
Transcript
Of
of what?
the 911 call
Of the 911 call?
that we are.
And have you had a chance to read that transcript while you're listening to the audio?
Yes.
And do they match?
Yes.
So you testified that the audio is accurate. Is the transcript accurate as well?
Yes.
Your Honor, I move to admit plaintiffs 4A and 4B at this time. Any objection?
None, Your Honor.
Those are admitted. Your Honor, at this time, I'd like to publish the audio for the jury, and as they listen to the audio, I'd like to have them follow along with the transcripts. So I've got copies for bailiff. That's allowable, you may do that. Here's as if all the jury members have copies. Your Honor, may I publish the audio? You may. If there were any technical difficulties, I may just have one moment. Sure. And while we're doing that, ma'am, when you were on the phone with this 911 caller, Ms. Howard, did you send responders to her location?
Yes.
And what responders were those?
Fire, EMS, were around, as well as law enforcement.
Okay, so sheriff's deputies and fire and EMS? Okay.
okay, you're doing great, take a breath, okay, okay. They're coming, I know, they're coming to help, okay, I need you to take a breath, okay? Thank you, good job, good job. Okay. Okay, so I'm getting them on the way to you, okay, I need to get this description, what race is he? What race is he? Stay calm, get Howard. Okay, well, you said he's white, how old is he? 57. What's he wearing? Okay, take a breath. Take a breath. You were arguing with him. What shirt was he wearing? Navy green. Okay. Player green. Okay, you're doing great. No. Okay, I need you to take a breath again. Okay, I know you're scared, but what's his name? Ken? Dan, and what's his last name? Howard? H-O-W-A-R-D? Okay, what's his date of birth? Okay, I know. What's his phone number, honey? 3221, is that the 208 number? Okay. Does he live there? Okay. You said he does live there, is that right? Is he there? Do you see him? Is he okay? Is he okay? Is he walking? What's going on? Okay. Does he have a gun? Is he a gun? Okay. Is he talking to you or you have to get suspended? Okay. Can you tell him, you're on the phone with 911? Okay. Is he responding to you? No. Okay. He's not responding to you, he's still walking in the field? Okay. Like he was in the field but now he can't see him? Okay. Figure it out. Yeah. Okay, so he was in the field last time you saw him? Yeah. Okay. And he was walking? Okay, so he's okay? Okay. Okay, he's just not talking to you? No. Okay. Is he able to hear you? Okay. Do you feel a long person out there talking to him about what's going on? Okay, I understand that. So I'm going to put one person come talk to him, okay? But you don't see a gun on him anywhere? No, I don't see it. Okay. I know you heard the gunshot, so can you please try to get his attention, get him to come to the house? If he doesn't have a gun? Dad, is he there? Is he listening to you? Okay. I'm just going to have you go back to the house, okay? Okay. Well, if everything's okay, you're getting one person trying to talk to him, okay? Hold on just a second. County County Fire, he's in the field, he's just not talking to her, he's walking around. Okay. Can we also put it here in that room? We ready to go? Okay, are you running off the data right now? Are you still there? Can you hear me? Yeah? Are you still there? Hello?
Your Honor, at this time I have no further questions from the witness. Take this one, cross-examination.
Good afternoon. So this was 7/10 of 2020? Okay. And you canceled fire and EMS, is that right? Law enforcement still showed up that day? Okay. No further questions, thank you.
Thank you, ma'am. Give me a second. Did you write something else?
Judge, if I may, I do think we can do the next witness fairly quickly. However, in the interest of time, not excusing the jury, we can just have just a very brief sidebar before we call that witness.
Sure.
State calls Andrew Mohawk.
Just for the jury, I figured let's just keep on pressing through and we'll stop right at 5. Obviously, I'm not going to keep you here past 5, so we'll stop in the middle of this witness's testimony. Take it back up again tomorrow. Thank you, sir. If you could raise your right hand, please swear in, please.
Do you solemnly swear that the testimony you're about to give in this case will be the truth, the whole truth, and nothing but the truth, so help you God?
Thank you, sir. Please have a seat.
When you're settled.
I was just saying you may inquire.
Thank you, Your Honor. If you could please state your full name and spell your last for the record.
Andrew Marcus Mohawk, M-O-H-A-W-K.
How are you employed?
Full-time patrol deputy with the Kootenai County Sheriff's Office.
Were you so employed on July 10th of 2020?
Yes, I was.
At that time, were you a post-certified patrol deputy?
I was.
And is that standard law enforcement certification in the state of Idaho?
Yes, ma'am.
Were you dispatched on that day to an address in Apple?
I was.
Do you recall that address?
I do.
What is it?
30276 North Lee Ridge.
Do you recall what time of day you were dispatched?
I believe I was dispatched just before 9 p.m.
Why were you dispatched to that address?
The call initially came out as a possible suicide attempt.
When you arrived on scene, who did you make contact with?
I had made contact with the boarding party, Kendy.
Who else was on scene when you arrived?
I believe her son, Wyatt Howard, was on scene as well.
Was there another individual that you attempted to make contact with?
Yes, ma'am.
Who was that?
I attempted to make contact with Kendy Howard.
And was that based on the information that you had received?
Yes, ma'am.
Can you describe the efforts that you made to have contact with Daniel Howard?
Yes, a cell phone number was provided during the initial intake of the call, so I attempted to call that provided phone number twice.
When you made contact with Kendy Howard, what observations did you make of her demeanor?
Initially, I noticed she was distraught, and I believe she had just gone through something traumatic, and she was crying during first contact.
When you made contact with her, you stated that this was about 9 p.m. in July. Is that correct?
That's correct. I believe I arrived around 9:30.
Did you make contact with her outside or inside?
Outside.
What was the weather, and by that I really mean the lighting, like at that point?
Very low light.
Were you able to make clear observations of the surrounding property?
I wouldn't say clear. I could see tree lines in a field, but no,
Did you ever go into the residence to look for Daniel Howard?
I did not.
Did you go into any shop or other outbuildings to look for Daniel Howard?
No, ma'am.
Did you ever observe either Wyatt Howard or Kendy Howard make contact with Daniel Howard?
I did not.
When you interacted with Kendy Howard, do you recall how she was dressed?
I don't.
Do you recall whether or not you ever spoke to Kendy Howard away from her son?
No,
And did she report any crimes to you?
she did not.
No further questions.
Thank you. Cross-examination, Mr. Johnson.
Good afternoon. Were you alone when you arrived? Or was there another officer with you?
There was another deputy with me.
Okay, who was that?
Deputy Franson.
And during this time, you asked about any physical injuries. She said she didn't have any, correct?
Correct.
Okay. And this was on 7/10 of 20.
Sorry, may I clarify that?
Yes.
I believe I asked if there was any physical contact during the argument.
And she said no, correct?
She said no. Correct.
No further questions.
Any regrets?
No, Your Honor, thank you.
Thank you, sir. You may sit down.
I would stop at this juncture.
All right, okay. Went faster than I thought, but we'll rather than take another witness with 7 minutes to go. We'll just break at this time for the day. Members of the jury, thank you again for your attention and your patience. And I'll remind you not to discuss this matter to yourselves or anyone else, nor form an opinion as to its rights until it's been submitted to you. Talk to my bailiff, or maybe they've already told you about where we'll be tomorrow at that courthouse, the parking and all of that, okay? I'll look forward to seeing you there. We'll plan to start at 9 o'clock, so you show up just a little bit early so that you're here in your seats and ready to go. Kick things off at 9 o'clock. All right, thank you.